So we're going to move on to one of our annual speakers who is here every single year, basically, and a guy that I really consider to be the foremost authority on everything regulatory that affects the internet industry that touches upon all of us, and that's Chris Tacit. And Chris is he's been working in this field. He's got a combined 41 years of technical, business, and legal experience. He's the founder of Tacit Law, which is a boutique law firm in Ottawa that provides a broad range of legal and consulting services to clients in the information technology, communications, regulated industries, and broader commercial and not-for-profit sectors. And he's also very involved in internet governance through a lot of his volunteer work with Vanex and Aaron. I believe he's at the Aaron meeting right now, which is why he can't be here in person. But Chris is a guy that has gone to bat for our industry time and time again with the CRTC, with ISED, with local governments, every branch, and has been a real champion. So he's going to give us a regulatory update on where we're at on the many proceedings, and it'll be a bit of a blitz because I think he's only got half an hour and could probably talk all day on the subject. So are we ready to switch over, James? We're good to go. Okay, well, I'll bring Chris Tacit to the virtual stage.
Thank you very much. I hope everyone can hear me. Good. So we're going to cover a few different topics. I'm not going to read them all. Now, I'm going to leave the slide deck behind for you folks. So my presentation of necessity will not have the same level of detail as what's in the slides, but that's intentional because I can only do so much in the half hour I have. But at the same time, if anyone has any questions about the slides once they get them, please feel free to follow up with me. I'll be happy to answer them. Okay, so first I want to talk a little bit about the ongoing process that was kicked off by the wholesale mobile wireless regulatory policy of the CRTC in 2021. And you'll recall that basically the CRTC mandated a form of MVNO access, but it was limited to parties that already had spectrum in Tier 4 areas. So really, it was for the benefit of the regional carriers. There were a lot of subsequent issues left to be addressed by way of a subsequent tariff process. I don't propose to get into them, but I just wanted to show you that it is a fairly extensive list of issues that needed to be resolved. One of the things that had to be addressed fairly quickly, because things are supposed to get underway quite soon, was seamless roaming. And indeed, the commission came out not long ago, either late March or early this month, I can't recall now, with its seamless roaming decision. And basically, it's meant to flesh out some of the details of the seamless roaming regime for the handoff of MVNO traffic when providers are roaming. So that's underway now. Interestingly, at the same time as that is all happening and the tariff details still have to be worked out, we've actually got appeals of the original regulatory policy still going on, at least one set, and that is TELUS, which has brought an appeal to the Federal Court of Appeal, one, to try and turn back seamless roaming, and two, claiming that the CRTC lacked jurisdiction to settle disputes between Canadian carriers and public authorities over highways and other public places when it comes to wireless infrastructure. So that's still going on, adds to the whole uncertainty of what will happen. One thing that did get resolved is a petition to cabinet that sought to broaden the MVNO regime to make it a full MVNO regime was dismissed by cabinet recently. It's just in the last few days, actually, late last week, I believe. So you can see on the wireless side, although there's some movement to try and promote competition, it's really too soon to see if this will be successful, assuming we get through all the appeals and the tariff processes, or whether, eventually the government will need to relent and require a full MVNO access regime, such as that which the competitive industry advocated for. Another important set of decisions relates to wholesale high-speed access, and this is in the wireline domain. And after a very lengthy process that took a number of years, the Commission in 2019 set wholesale rates, only to then, following incumbent appeals, reverse itself very substantially in this year, or in 2021. So that's a problem for the industry. That's a significant problem for the industry. There are 3 petitions to cabinet that call for this decision to be rescinded and the previous one to be restored. Tech Savvy is also appealing this to the federal court. So again, uncertainty, high costs for the industry. While all of that is going on, the Commission had signaled a few years ago that it wanted to move from an aggregated to a disaggregated wholesale high-speed services configuration model. In other words, to unbundle the transport piece from the access piece. And the theory behind that, according to the Commission, was that people would either build their own transport or there was competitive transport out there. I'll talk about the transport issue in a bit, but first, what had to be decided was how many of these points of interconnection could be aggregated within a disaggregated configuration, because you can't really completely disaggregate the networks of the incumbents. You'd end up with thousands of locations. And initially, when they tried a full disaggregation model, it became apparent pretty quickly that it wasn't going to work. So they went back to the drawing board on that particular aspect of the decision, and they've been revisiting the level of disaggregation. We think that the record may be closed on that and a decision may be coming soon, but it's not entirely clear yet. Now, while this was going on, CNOC filed a Part 1 application requesting a temporary resale remedy for FTTP. And the reason for that is that it was only through disaggregated wholesale services that access to FTTP facilities of the incumbents was mandated. So until that becomes workable, basically competitors have no access to the FTTP platforms of the incumbents. So in the meantime, CNOC filed a Part 1 for a temporary resale remedy until that occurs. The record of that proceeding, and it was labeled, urgent, expedited, whatnot. The record of that proceeding closed early last year, and there's still been no decision one way or another. More recently, Distributel filed a Part 1 application to basically say, if you've got interim rates for disaggregated services, they shouldn't be any higher than the final aggregated rates for equivalent services, which intuitively makes sense because you're taking out the whole transport piece from the service. So therefore, a disaggregated rate should be lower or no greater than the aggregated rate. That was filed fairly recently, and we'll see what traction that ends up getting. Now, I talked a little bit about the transport problem, and I want to focus on it a little bit because, in my view, this is probably the central problem for competition right now on the wireline side. As I said, in 2015, the Commission made the assumption, or I guess found, based on a national analysis, that transport was sufficiently competitive that it didn't have to regulate incumbent transport. And that followed a pattern, a fairly lengthy pattern where transport has been forborne from rate regulation for some time. The problem is that in a number of ways, it's becoming more and more apparent that the lack of competitive transport and the lack of transparency regarding where transport exists are serious problems and impediments to competition. And indeed, when we look at a disaggregated wholesale services access regime, it really won't work without competitive transport being available, because it's really not feasible to expect competitors to build out transport to tens or hundreds of POIs throughout Canada so that they can get access to FTTP in every corner of Canada. It's just not going to happen. So if it's then impossible as a second step, as a second choice, to negotiate a deal with incumbents or other parties for that transport, then you're kind of really stuck and the regime isn't going to work. And there are some other indicators besides the direct indicator that there isn't competitive transport. But recently we've seen, for example, incumbents try and charge hefty construction fees or create other impediments to connect up buildings, multiple dwelling units, to competitors, so that the competitors can use their own inside wire in those buildings to deliver services to the buildings. And even though there's sometimes lots of capacity, they don't want to share it, and they force new construction through large fees that makes those kinds of projects infeasible. Another recent example is Eastlink, out in the opposite end of the country from where you guys are, put its TPIA POI about 32 kilometers outside of the core of Halifax at a data center it has at a place called Pennant Point. And the reason that data center exists is because it is a landing point, that particular area, for an international submarine cable. Other than that, there's really nothing else around there. And so because there was no competitive transport, a company called Citywide, which is one of the most significant competitors to Eastlink, had to also buy its transport from Eastlink. And of course, Eastlink was able to charge fairly non-competitive rates relative to one might find in Halifax, the core part of Halifax, for example. Despite all this, the CRTC recently denied Citywide's request to have that POI relocated. So these are just a few kind of spearhead examples of the broader transport problem, which I think it really needs the attention of the industry right now. I want to turn to a few other miscellaneous topics in the time I have left. You will probably all know, and I won't get into details because I think there are other talks about this in your program, about some of the BC broadband funding that's available. And the CRTC recently approved 3 BC related projects by 3 parties as well. A decision that does affect communication service providers of all sizes and shapes is a paper billing decision. And basically, it requires communication service providers to provide paper bills to certain classes of consumers, and you'll see those in the last 3 bullets on this slide. So if any of your customers fall into those categories, then on request, they're entitled to get paper bills at no charge. You can also choose to provide paper bills in other circumstances, but they do have to be provided free of charge in at least those 3 circumstances. And, CSPs must also make it clear how paper bills can be requested, as you see in the second part of this slide. And they have to train their customer service representatives to deal with these issues, inform new subscribers of their rights, and so on, and receive verbal or written consent prior to transitioning customers who don't subscribe to internet access or mobile data services from that provider to electronic billing, and so on. So it is, and there's some additional expectations here. Again, I won't try to go through all of them because I would run out of time, but you do need to be aware of this requirement as a communication service provider. Also, there's some technical aspects to this as well that you will want to consider. So another interesting situation, again, going a little bit back to the wholesale high-speed thing, providers, what Shaw kind of leading the way, had been arguing that, in order to put them on a more equal footing with providers of fiber to the prem, because you can get fairly high speeds over cable networks using DOCSIS 3.1. You don't need fiber to the prem, so they're doing it over copper or their HFC networks. But they wanted to create a more restrictive environment for wholesale services over a gig. And in this case, the commission basically denied Shaw's request. And fortunately, the regime that applies to lower speeds at least applies to those aggregated services. Another big issue has been that, okay, you get these services, but they're not always delivered properly in a timely manner when it comes to installation requests, disconnection requests, maintenance, repair, and so on. So following quite a tortuous process, fraught with significant differences of opinion between incumbents and competitors, the commission came out with a regime whereby incumbents need to report on their quality of service. In other words, not just have to deliver the service, but report on the quality of things like what their intervals are for dealing with orders, installations, repair, and so on. So they have to start reporting this by the end of this month. So we're going to see the first reports under this regime at the end of this month. One of the issues that's been pretty live for IP-based voice calls is to prevent fraud. And the way to do that is a token-based security system fondly called STIR/SHAKEN. And that is now in effect, and all telecom service providers have to report on their progress by May 31st. There are a couple of spectrum consultations going on. I'm not going to get into details, but essentially in the above 95 gig range, there's a debate here about how much of this should be license exempt, whether those that are designated for backhaul use and licensed, whether some should be designated for that and so on. And then there's another one right now for radio devices in the 5850 to 5895, and basically to extend that regime, that license exempt regime up to the 5895 band as well. And also wrapped into that is now the discussion about should there be certain standards for the use of this spectrum for certain types of IoT applications, like cellular vehicle to everything and so on. So that's another interesting one. One kind of residual issue from the 3500 megahertz auction is that there are some technical rules that were introduced to prevent conflict with airport radio altimeters, or airplane and airport altimeters, I should say. And the Radio Advisory Board of Canada and ISED are working to resolve some of these potential interference issues to ensure, obviously, the aircraft safety. And so that work is underway. And Brenda, who's in your midst, can probably talk to you more about that if you're interested. One of course, the big things that's been in the news is the Rogers acquisition of Shaw. There are basically three types of regulatory approval required for that. One is the broadcasting side, the broadcast licenses. The other is from the Competition Bureau, just generally with regards to competitive effects. And then there's also ISED with regards to the spectrum. The broadcasting part of this has been decided now, and you'll see the core findings, the most important findings are there on this slide. And based on recent reports, it looks like there are at least three suitors vying for Freedom Mobile to purchase it from Shaw, because that will undoubtedly be a condition. The minister's already said that he's not going to approve a deal where Rogers keeps the Freedom Mobile business, essentially. So they have to divest it, and there are, according to the press, at least three parties vying for that. Some legislative initiatives that are in play right now. One is the Online Streaming Act, which basically would subject streaming services to more traditional broadcasting types of regulation, which requires them to contribute to Canadian content more explicitly. There's another piece of legislation, the Online News Act, that's intended to require online platforms to pay for news that appears on their platforms. This is to give a helping hand to the newspaper industry in Canada. I wanted to, just before concluding, talk a couple of minutes about employment law, and just to refresh, recall that when it comes to telecommunications, it's federal and not provincial employment law that governs, although there are certain provincial laws of general application that can also apply, such as, for example, those relating to workers' insurance. So what that means is that even if you're in BC, it's the Canada Labour Code and not the BC Employment Standards Act that applies. Having said that, sometimes the Canada Labour Code incorporates certain things from the provincial legislation in order to be sensitive to regional conditions. So if you look at the top right-hand square of this table, you'll see that because the BC rate has gone up above the baseline federal rate, federally regulated employers such as telecom service providers have to pay the new rate under the BC Employment Standards Act. On the other hand, one area where there's still a difference is in terms of sick days. Federally, you're required to give 3 paid sick days, provincially 5, but soon that could change because there is an amendment which is not yet enforced that would increase federal number of sick days to 10. So you got to be careful in this area to make sure you're following the right rules. And you'll see that there are some other requirements here to the Canada Labor Code that apply to telecom service providers. And I'll just let you read those on this particular slide. Another big change is the new Pay Equity Act. Any federally regulated employer with more than 10 employees has to have an employment equity plan established to ensure that work of equal value is compensated the same regardless of gender. And so that's something important. So I know it was a bit of a whirlwind, but I wanted to stay within my time limit. So that's kind of my presentation. And if we have any time for a few questions, I'll be happy to take them. Otherwise, I'll turn it back to Chris.
Okay, great. Well, thanks, Chris. That is once again just action-packed. You could pay a lot of money to get that kind of knowledge pumped into your brain. So that's pretty great work, Chris.